Rolling. We're back on the record. Before I ask the board members if they have questions, anything else from any of the parties from Ms. Campbell at this time? Mr. Reid?
No questions.
Mr. Takei?
I just wanted to make note that the DOE rep Sean Bacon is now in the boardroom, but no issues.
Welcome again, Mr. Bacon. Mr. Alapa?
Okay for me.
Board member Moipon?
I have
Yep.
no questions. Thank you.
Board Chair O'Shea?
Yeah, real quick. So Ms. Campbell, prior to the repricing, how many years of experience did you have working as a DOE teacher?
Prior to repricing, I had a total of 12 years.
And of those 12 years, how many of them were what portion of that was part of the initial 6 years credit?
Oh, I'm talking, I had 12 additional years. Was given the 6 years credit
Okay,
when I started.
Yeah.
I had 1 year prior to that in the year, I believe 2000 to 2001. So I had 1 year of experience, then I was granted 6 years. And then I had an additional 12 years.
okay, so when did you so 1 year from 2000 to 2001
Correct,
with the DOE,
correct,
and then you left, right?
correct.
And when did you return?
The fall of October of 2010,
2010,
correct,
and that's where you got the 6
years.
years credit
correct,
for working outside the DOE, outside of bargaining unit 5.
correct.
Okay. And then from October 2010 through
Till repricing in November 2020, so it was 12 additional years.
additional years. Okay, so your complaint is that with the 6 plus the additional 12 years, you should have had the 18 years of credit
I should have had 18 years on step 13,
at step 13.
correct.
And instead, what did you?
I remained at step 11.
Okay, so you had 18 at step 11.
No, yes, I did. That is correct. I had 18 at step 11.
Okay. And then, so there's a difference between being at step 11 and step 13.
There's a monetary difference, yes, of about $7,390 odd.
Okay. And you raised that with the Department of Education,
I did multiple times.
and that's where you learned that there was no appeal from that decision?
Correct. I was told by the Department of Education, I believe it was October 2nd. I believe I submitted that as one of the exhibits where the Office of Personnel said there was no appeals process to compression.
Okay. No, thank you. Thank you very much. Thank you, Chair.
Ms. Campbell, the 6 years credit of service, is it your understanding that, or up to the 6 years, that's something that's determined by the Department of Education?
Yes,
Does HSTA have anything to do with determining the up to 6 years
no,
of credit? Well, thank you. I have nothing further this time. Mr. Reid, anything else?
No questions.
Mr. Takei,
No questions.
Mr. Lapa,
Nothing from me. Thank you.
and thank you, Ms. Campbell.
thank you.
Schools. Mr. Reid,
We have no more witnesses in our case against the department.
Ms. Best, you're choosing not to testify. Mr. Reid, if you have no more witnesses, are you resting your case for yourself and for Ms. Campbell and Ms. Best?
Yes.
You? Mr. Takei?
At this time, based on the evidence presented by testimony and exhibits, the DOE moves for a directed verdict in its favor. With the board's approval, I would like an opportunity to explain.
Yes, please proceed.
Okay. According to the Hawaii Supreme Court, a directed verdict may be granted when, after disregarding conflicting evidence, giving to the complainant's evidence all the value to which it is legally entitled, and indulging every legitimate inference which may be drawn from the evidence in the complainant's favor, it can be said that there is no evidence to support a judgment in their favor. Here, complainant's evidence cannot prove that DOE willfully committed a prohibited practice under HRS 8913A1, 7, or 8. First, the evidence cannot prove that DOE violated their employee right of self-organization or any other right enumerated under 89-3. This is because the complainant's evidence cannot prove that DOE was required to negotiate repricing under 89-9 or under any other mandate, either legislative or statutory. The evidence cannot prove that DOE did not have the discretion to implement repricing without negotiation pursuant to 89-9F2. The evidence cannot prove that DOE did not have an established procedure to periodically review repricing. Therefore, the evidence cannot prove that complainants were entitled to any negotiation of repricing that DOE interfered with, forced complainants out of, or restrained complainants from. Further, the evidence cannot show that the complainants, as employees, have any right to compel negotiation under 89-9. In contrast, the evidence does prove that the legislature did not require negotiation. The evidence does prove that 89-9F2 gives DOE the discretion to implement repricing without negotiation. The evidence proves that DOE had an established procedure to periodically review repricing each time the collective bargaining agreement was renegotiated. And it proves that HSTA agreed that negotiation was not necessary. Second, complainant's evidence cannot prove that repricing violated the merit principle of equal pay for equal work. The evidence cannot prove that the complainant's non-BU5 service is required to be paid equally to BU5 service under the principle. The evidence cannot prove that the BU5 service that complainants are currently acquiring is not being equally paid for in comparison to others in BU5 of the same step and class as themselves on the salary schedule. Complainants' evidence has only shown that they desire their non-BU5 service to be considered equally. Third, complainants' evidence cannot prove that repricing violated any article of the CBA. The evidence cannot prove that there is a guarantee in the CBA for complainants to be placed on the same step as in-service teachers with equal years of service beyond initial placement into perpetuity and for repricing. It cannot prove that repricing caused any negotiated step movements. The evidence does not prove that same step placement was only guaranteed. The evidence does prove that same step placement was only guaranteed for initial placement and for no other purpose. The evidence does show that no language in the CBA prevents step movements based on discretionary repricing by the employer. Finally, the evidence cannot prove that repricing was discriminatory against any protected class, including race. The evidence only proves that repricing was based only on BU5 service, which does not exclude any protected class. For these reasons, there is no evidence to, to support a judgment in complainant's favor, and a directed verdict should be granted. Thank you.
Thank you, Mr. Takei. Mr. Reid?
I move that we do not grant that motion. The evidence proves that there is enough doubt in this. There's enough evidence that we do have a chance to prove our positions. I don't think I'm supposed to repeat everything that just happened for the past 2 days, but I'll recap on a couple of things. Number one, the state has not produced any evidence of their procedures. They have not produced any testimony or any memorialized data that they follow their procedures. They have not produced any evidence that there are independent reviews of repricing. They have also not produced any evidence that that repricing was even on any of their minds throughout the process until the very last second. And if you just learn about a process at the very last second that has requirements such as the establishment of procedures and to have the reviews of repricing, you can't just magically go back and say, oh, this counts for that, this counts for that, this counts for that, which has been what they've demonstrated. They've demonstrated that they found this law. The evidence is proven through my description of the timeline of this repricing effort, that repricing was at the 12th hour. And at the 12th hour, they cannot go back and invent things that cannot go back and convert things that they did prior to fill in the requirements for what they should have done to begin with. Yeah, it is very clear that the wages of the members of bargaining unit 5 were changed. They were increased. The monetary values went up, and the wages are a core issue here. And wages are the core issue of 89. Well, it's one of the core issues of 89.9. For the reasons that at the very minimum there are things in question, a directed verdict should not be made.
Thank you, Mr. Reid. Mr. Takei, anything else to add?
Just to respond, the argument that repricing was a 12th hour decision cannot be substantiated, given that in Act 248, the legislature required the money to be used for repricing. The 12th hour, describing as 12th hour, seems to indicate that this was a snap decision much later in the process. However, it's been clear that it was the legislature's intent that repricing be done, and 89.9F2 is simply authority to that sets out when the employer can use its discretion to implement repricing. The argument that that the established process was I guess in any way not a genuine process is controverted by the fact that it occurs every time the renegotiation of a collective bargaining agreement is done. and to argue that discussions that lead up to and include or take place during the collective bargaining meetings has no form or is somehow without any procedure is a disingenuous argument. And since it appears that this case or claim that employee rights are violated is contingent upon whether or not the use of 89.9 F2 was proper, the DOE would submit that the established process does not need to be written. It does not say in the statute that it needs to be a written process, and therefore the use of 89.9 F2 discretion was proper, and this claim or the DOE is entitled to a directed verdict in this case.
Thank you, Mr. Takei. The board is going to take a recess, subject to the call of the chair. Reid.
Rolling.
Back on the record. The board, having conferred and taken into account the legal standard for a directed verdict, hereby deny your motion, Mr. Takei. So with that, are you ready to present your case?
Yes.
Please proceed.
Okay. DOE would like to recall Mr. Bacon.
Mr. Bacon? Since you've already been sworn, Mr. Bacon, I'll just remind you, you're still on the roll.
Yes, thank you.
Thank you. Mr. Takei?
So you've already testified to a lot of things. I just wanted to ask additional questions in a couple areas. Are you familiar with the merit principle of equal pay for equal work?
Yes, I am.
Can you explain what that principle is?
Basically, a merit principle would be treating those equally within the bargaining unit for bargaining unit work that's been done in the bargaining unit.
Okay. And treating it equally, meaning paying for the work equally?
Yes,
Is that what you mean by
equal. Yes,
treatment? Okay. Does the merit principle require BU5 work and non-BU5 work to be treated and paid equally?
so the merit principle, from my understanding, is that it should be equal pay for equal work within the bargaining unit. Work outside of the bargaining unit may be different, and it wouldn't fit within the merit principle.
Okay. So say you worked at a private school, you bring that non-BU5 experience to DOE. Does DOE have any obligation to pay for that non-BU5 service?
For the non-BU5 service, the department, as in the school code and also in the collective bargaining agreement, we would look at providing up to 6 years of experience to be credited towards initial placement.
Okay. But the merit principle wouldn't require it.
No.
For what purpose does DOE consider non-BU5 service?
What purpose does DOE consider non-BU5 service? So non-BU5 service would be service that is then done outside of the department. It would be work that would be possibly on the mainland or at a private or non-DOE school.
So what purpose does DOE consider that type of service?
So we consider it service that we would consider for initial placement, but it may not necessarily be equal work.
Okay.
That would be considered.
So does DOE consider non-BU5 service or any other purpose other than initial placement?
No, just for initial placement.
This is gonna be tricky because I only have one copy of these bargaining agreement, but
What year?
21,
23.
Yeah. Oh, okay, thank you. Can you turn to Article 20?
So do we have a copy?
Board Exhibit 1.
Yeah, it's Board Exhibit 1.
Oh, I can go. It's,
No, the board exhibits, these weren't emailed in the three, so I didn't get a bait stamped board exhibit, so I didn't print it.
so maybe you could tell me which section I might have it.
E, the one that
Article 20, section E?
the one we've been
Okay.
talking about.
Gotcha.
So are you familiar with that section E?
Yeah, Article XX salaries.
Yes, section E.
Okay,
Are you familiar with that
yes,
section? Is it part of your job duties to understand and apply this section?
that is correct.
Okay. In the first sentence. Do you see where it says new hire teachers entering the salary schedule in 2021 through 2023?
Yes,
Okay. Is that the type of teacher that this article section E applies to?
so section E applies to any new employee or new teacher entering the department.
And, new hire teachers entering the department.
Correct.
Okay. Is there a specific year that this article applies to?
So any new hire teacher entering this between 2021 and 2023.
So is it your understanding that section E is only those teachers that section E applies to?
So section E applies to any new teacher entering and being initially placed on the salary schedule from 21 to 23 would be placed, on step 5, for example.
Okay. Let me ask a different question. Does section E apply to any other type of teacher besides new hire teachers entering the salary schedule in 2021 through 2023?
No, it is only just for, this section is used just for those that are initially entering the salary schedule.
What about incumbent teachers? Does any part of this section apply to incumbent teachers?
No, this section only applies to new hire teachers entering the salary schedule.
Okay, if you can look at the second sentence that starts with those teachers. What type of teacher is that referring to?
Those teachers, that would be those that are being hired and entering the salary schedule.
Okay, so the same type of teachers that section 1 is talking about?
Yeah, that first sentence, yes.
Okay. Now, if you can focus your attention on the third sentence, where it says, no more than 6 years of verified non-DOE teaching experience may be credited as determined by the DOE. You may have answered this already, but does the DOE give 6 years of verified teaching credit or non-BU 5 service to any other type of teacher besides a new hire teacher?
No, it's only for new hire teachers.
Not incumbent teachers?
So no, it is not for incumbent teachers. We do an evaluation of their 6 years of service upon entering into the department.
Okay. Does section E deal with initial placement?
Yes, it only deals with initial placement.
How do you know that?
As it talks about new hire teachers entering the salary schedule.
Okay. So that's how you know that this section only applies to, only deals with the initial placement.
Yes, it's for new hire teachers.
Okay. Is there any indication in this section that it deals with any other type of placement?
No, it's only for initial placement.
Does this section indicate anywhere that it deals with placement for repricing?
No, it does not.
Okay. Now, if you can go back to the second sentence. Does that second sentence guarantee that an incumbent teacher will have same step placement and movement with in-service teachers with equivalent years of service forever?
No, this only talks about initial placement and initial placement only.
Thank you. I'd like to move to different questions, a different area. What impact did repricing have on teachers?
The impact that it had is it had a positive impact on teachers. It allowed teachers with bargaining unit 5 experience to be repriced to another level. It did not at all have any negative consequences. Nobody's salary, from their step and range, the actual dollar amount in that salary, nobody's salary was less than what they were prior to repricing.
Okay. What about steps? Did any teachers lose any steps due to repricing?
No,
What about any type of benefit guaranteed by the collective bargaining agreement?
no benefits were lost.
What impact did repricing have on the collective bargaining agreement itself?
There was no changes to the collective bargaining agreement at all.
Okay, you didn't have to change one word in the whole CBA.
No, nothing was changed in the CBA.
And the salary schedule, no changes as well?
No, there was no changes to the salary schedule.
What about section E, article 20? No changes? The one
No.
that we were just talking about?
No changes.
So the initial placement policy never changed?
No.
Can you turn to Article 3, negotiating rules. This is on page 2.
We don't have a call.
Okay, I don't need to see it. Do you see the section that says negotiating rules?
Yes,
When are those rules used?
during the time of the collective bargaining process.
Okay, so earlier you were, correct me if I'm wrong, your testimony was that repricing and salaries and teacher salaries, those types of issues were regularly discussed at collective bargaining agreements. Is that what you testified?
Yes,
Okay. Are you required to follow those negotiating rules in Article 3 when you had those discussions during a CBA renegotiation?
yes,
Okay, and these are the same CBA discussions that these are the same CBA negotiation discussions that you described as established procedures under 89.9 F2.
so yes, under 89.9 F2, you know, I testified to say that typically, at each time that we reopen the collective bargaining agreement to discuss the collective bargaining agreement, that the parties typically do talk about wages, salaries, and those types of things. So this always gives us an opportunity to look at that during that time.
And would you say that during those times you followed the negotiation rules set out in Article 3?
Yes, we do follow the negotiating rules in Article 3.
Okay, thank you. Now, you testified earlier that DOE consulted with HSTA about repricing. Is that correct?
That's correct.
What was discussed during those consultations?
So what was discussed during those consultations is, you know, how we were going to implement the repricing, where was the eligibility of individuals, were people going to be negatively impacted, was there going to be any type of decrease in the individual salary during that. Also, like I testified previously, we had discussed if bargaining unit 5 and non-bargaining unit 5 experience would be incorporated. So those are some of the things that were discussed when we consulted.
Were there discussions to ensure that repricing did not impact the CBA?
Yes,
Were there discussions to ensure that repricing did not violate any of the articles in the CBA?
yes,
Were the complainants involved in any way in the development of the repricing plan?
not to my knowledge.
To your knowledge, did the HSTA ever ask for complainants' assistance?
Not to my knowledge.
Can teachers directly negotiate with DOE without their union?
No, the exclusive representative or the exclusive rep needs to negotiate with the department and the state. Teachers can't individually negotiate.
Were any safeguards put in place to make sure that repricing was done correctly?
A couple things. I think that when the parties were talking, we knew that sometimes people may feel more comfortable going to their union. We also knew sometimes people may be more comfortable going to the employer. So we wanted to make sure that there was an opportunity on both sides. So if individuals did have questions about repricing, they could definitely contact their union. Also, there was an opportunity for individuals if they wanted to see about their verified bargaining unit 5 experience, that they could contact our records and transactions section. Our records and transactions section could then do a review of the bargaining unit 5 experience to make sure that we did calculate it correctly.
Okay. Okay. Were any of these complainants in this case were any of the complainants in this case new hired teachers entering the salary schedule in 2021 through 2023?
Not to my knowledge, no.
Okay. Why is that?
They were already employed with the department prior to 2021.
Okay. Because he testified that earlier that part of your job duties to apply CBA to teachers. If you can look back at Article 20, Section E. Would you say that the complainants even that Section E even applies to these complainants?
Well, when this section in this current collective bargaining agreement would not apply to them because they were already hired and were already initially placed on the salary schedule at the time of hire.
Okay, so it's your opinion that these complainants, according to this collective bargaining agreement for these years, this Section E does not apply to them. Is that what you're saying?
I would say it does not apply to them because this is about initial placement and they were already initially placed when they were originally hired with the department.
Okay. Is another reason why this section doesn't apply to them because they did not enter the salary schedule in 2021 through 2023?
Yes, they didn't enter it. They were already had been placed on the salary schedule at that point.
Okay. And so your understanding that at the time of the initial placement, the complainants each received 6 years of verified non-BU5 credit.
That is correct.
And what effect did this have on their initial step placement?
So it had a positive effect on their initial step placement. We were able to credit them for their 6 years of verified non-DOE experience and was able to give them an appropriate step increase from the base step of step 5 upon their initial placement.
And at the time of initial placement, were the complainants each placed with other in-service teachers with equivalent years of service?
Yes,
Earlier you testified that the eligibility of repricing was for teachers that were employed at the end of 2022 school year. No, 2021 school year, and was still working at the beginning of the 2022 school year. Is that correct?
that's correct.
Okay, so were the complainants eligible for repricing?
Yes, they were.
So they were considered.
Yes, they were.
And were complainants' years of BU5 service considered for repricing?
Yes,
So it's not like the repricing plan passed any of these complainants over, like, right?
no, because they were employed at the end of 21, beginning of 22 school year. And we considered all of their bargaining unit 5 years of experience toward the repricing plan. Yes,
Okay. And the repricing take away the 6 years credited to them at that they received the initial placement.
no, it did not.
So it's still on their record. Is that right?
Yes,
And the repricing take away any of their steps?
no, it did not.
What about their accumulated BU5 service?
No, it did not take away that either.
Change or take away their pay?
No, there was no loss of pay.
Rights, benefits, and privileges guaranteed in the CBA.
No,
How many teachers have filed a grievance against DOE regarding repricing, to your knowledge?
my knowledge, I believe it's 4.
So there's the 3 complainants here and 1 more person.
Correct.
Do you remember the name of the last person? Speaker?
Jennifer Kramer, I believe.
The DOE in any way prevent complainants from being a part of HSTA?
No,
Do they prevent them from self-organizing a different group, collective bargaining?
no,
Did DOE have any knowledge about whether complainants were even self-organizing to begin with?
not to my knowledge.
Did DOE prevent complainants from forming a separate employee organization?
No,
And any indication that they were forming?
not to my knowledge.
Did DOE prevent complainants from joining another organization?
No,
Was there any indication that they were even trying to join another organization?
not to my knowledge.
Did DOE prevent complainants from assisting HSTA in negotiating repricing?
We did not.
Was there any negotiation to even assist with?
No,
Did DOE prevent complainants from engaging in any collective bargaining activities related to repricing?
no,
Were there even any such negotiation activities to engage in?
no.
Why? Why not?
Because this was not done through negotiations. This was done at the employer discretion of using 89.9 F2.
Okay. Did DOE do anything to force complainants to engage in any type of union activities?
No,
Did DOE prevent complainants from pursuing their concerns about repricing with HSTA?
no.
I don't have any further questions.
Thank you, Mr. Takei. Mr. Olapa, do you have any questions?
No questions, thank you.
Thank you. Mr. Reid, cross-examination.
Yes, I do. Where do you get your understanding of the merit principle?
Equal pay for equal work within the bargaining unit.
What authoritative document does your understanding come from that includes within the bargaining unit?
That is my understanding. It's equal pay for equal work. I mean, it's work with that are under a particular collective bargaining agreement. That is the same type of work within that job class.
I hear you, but my question was, what authoritative document do you get your definition from?
From the merit principle.
So there's a document that says merit principle and it has, like, I'm asking for, does it come from a statute? Does it come from a ruling? Does it come from a law? What authoritative document do you base your understanding of the merit principle on?
My understanding is merit principle is in HRS, I believe.
Do you know where? The number?
I don't know off the top of my head.
When is the last time you have read that document?
I'd have to, I don't know the last time I read it.
All right. It's
Okay, go ahead.
So you based your previous testimony then on what exactly? Well, your previous testimony about the merit principle, you based upon what source of authority?
Has been answered.
Okay. I lost where I was. Okay, so
Objections overruled. Go ahead, Mr. Reid.
so
No, the objection is overruled. You can go ahead and ask.
I asked the question. Okay, so just to be clear, you just testified what your understanding was, and you cannot tell me the source of your information. Is that correct?
So merit principle comes, I believe it's out of HRS, but yeah, it talks about equal pay for equal work. And again, bargaining unit 5 work within the bargaining unit is equal. That type of that type of work, teaching work, whatever, in another state or another private school or whatever, that work may not be the same. Hours worked, those types of things. So it's not necessarily equal pay for equal work. So yeah.
So my next question is, what is work?
The job duties and responsibilities that are required for that employee within that class of work to complete.
So work is a action carried out in the present. Would that be, is that correct?
Not necessarily.
How could it be in the past?
So you would look at the work that is required of a bargaining unit 5 member, but you could also look at the work that is required of a teacher member outside of the Department of Education. You know, what's required of one may not be required of the other, and it wouldn't necessarily be equal work for equal pay.
So you would compare work done in the past that has already been compensated for, the work being done in the present to be compensated for as comparable.
So again, I think we are comparing apples to oranges. I mean, equal pay for equal work, which is all within the bargaining unit. What occurs outside of the bargaining unit, in another jurisdiction, for example, or another agency, there may be different requirements that are put on a teacher, for example, additional hours that are put on. So, we wouldn't be able to compare exactly the same between bargaining unit 5 and other other teaching positions.
Does the DOE fulfill the merit principle by giving credit for 6 prior years of experience upon initial hire?
So the DOE fulfills the requirement that's in the collective bargaining agreement and also in our school code about giving up to 6 years of teaching experience to be credited towards initial placement.
And in the case of us complainants, that is on the legacy salary placement before repricing.
That is correct.
So would you say that the salary placements after repricing are significantly different to the salary placements, to the way salaries were placed before repricing?
So after repricing has occurred, the salary placements, again, the collective bargaining agreement has not changed, so that the way that we're continuing to do salary placements is the same.
So is it your testimony that I received 1 step for every 2 years of experience prior to repricing?
No.
Were the people, when repricing happened, did people get 1 step for every 2 years?
So yes, the repricing allowed for, if you were employed the end of 21 to beginning of 22 school year, we looked at bargaining unit 5 experience, and for every 2 years of bargaining unit 5 experience, we gave 1 additional step.
So do you consider those two systems, the pre-repricing and repricing, do you consider those two things equal?
I don't think you can compare the two.
Are you saying they're the same? They can't be compared?
So there's initial placement that we look at to be able to place people on the salary schedule. And then once people were on the salary schedule, then the department implemented repricing from there. That was not about initial placement. The repricing dealt with after you were initially placed on the salary schedule.
So I'm trying to ask, which system is more beneficial? 2 years per one step, or a system that had negotiated increases over a period of 30 years that were not getting a lot of steps over the course of the time? Which of those two systems, to your knowledge, is the most beneficial?
Objection, argumentative.
And Mr. Reid, if you rephrase your question.
Was repricing an improvement over the status quo?
Repricing was a way to address bargaining unit 5 teachers that did not receive salary step increases over a period of time. And it was a way to decompress them and give them the step increases that they did not receive while they were employed with the department.
I interpret that to mean yes. Is that correct?
Yes to what?
That was repricing an improvement over the status quo. That's that question I can't ask again.
Just go ahead and
Yeah,
finish your question, and then
yeah,
if there's an objection.
Does our experience exist in two separate systems? Meaning we have 6 prior years in one system, and we have our current BU5 service being evaluated differently.
So there's an evaluation done at initial placement that allows for up to 6 years of non-DOE experience to be considered. But then when we did repricing, we did only considered bargaining unit 5 experience at that point to be able to move people on the salary schedule. So I mean, it's 2 different systems. One is talking about initial placement. The other is talking about once placed, how to move on the salary schedule.
I'll say it like this. In repricing, my service was worth 1 step for 2 years, correct?
In repricing, your bargaining unit 5 experience was worth 1 step for every 2 years of bargaining unit 5 experience.
And my prior experience was worth 2 steps for 6 years. Is that correct?
So your prior experience, we would give up to 6 years of service credit. And I think you could be placed a maximum of, I think, up to the 7th step.
And is it your position that those 2 things are equal?
Those 2 things are very different things because one talks about initial placement, one talks about initial placement of non-bargaining unit 5 experience, where the other talks about movement of bargaining unit 5 experience.
The value of the years per step, just the mathematical value of the years per step is 2 for 1, the same thing as 6 for 2.
Objection, vague, ambiguous, confusing.
I'm gonna sustain that
Okay.
objection and have you re-ask another question.
I receive steps in repricing at a rate of 1 step per 2 years, correct?
In repricing, yes.
I received in the initial placement of myself on the salary schedule, I received steps at a rate of 3 years for 1 step, resulting in 2 steps because I had 6 years. Is that correct?
We provided no more than 6 years of verified teaching experience for initial placement, which could have been 1 to 2 steps, depending on the year hired and things.
And in my case, that was 2 steps, correct?
I believe so, yes.
Does Article 20, Section E mention the merit principle?
No, it does not.
Did you just give testimony? So that's argumentative. Is repricing resetting everybody's position on the salary schedule based upon their years of experience?
Repricing is adjusting where individuals are on the salary schedule depending on their years of bargaining unit 5 experience.
Is this not similar to re-entering the salary schedule?
I do not believe so.
So did people in repricing receive an across the board step increase up the block, up the cell?
People in repricing, yes, they were able to move up to different class
Did everybody?
based on the eligibility requirements of everybody in every class was eligible for it, depending on the criteria that was developed.
So people were taken from one spot and then placed in another, or they moved up one spot. So were they taken off and moved? Because there's, let me reform my question just a hair. The typical behavior for step motions is across the board, one step everybody. Is that correct?
Typical movement once across the
Yeah,
board.
once steps are negotiated, typically everybody gains one step, correct?
Through typical negotiations, yes.
In this case, people were moved more than one step. It was not sequential motion. Was it correct? It was not sequential motion, correct?
Some people could have been moved more than one step, yes.
Yep. And is that not the same thing as leaving and re-entering the salary schedule? Because we're off of our track.
I would say no. Typically when you leave, it means there's just a separation action from the department where you've actually left and are no longer employed with the department. And then when you re-enter, that's when you're reappointed or initial hire with the department. So you're put on the salary schedule once you've been re-employed or employed.
Typically, was repricing a typical action for the DOE?
This repricing was not typical. It was something that we've done repricing before with other classes of work. But the way that we implemented this was through 89.9 F2.
On the next topic. You testified that you had conversations or safeguards to prohibit people from having a negative, what word did you use? Impact, is that correct?
Correct.
Okay. Do you consider being passed over for a raise a positive or a negative impact?
What we wanted to ensure with those safeguards is that anybody that was on the salary schedule did not move lower on the salary schedule than where they were.
That wasn't exactly my question. My question was, is it a positive or a negative impact when someone is passed over for a raise?
Objection. His use of the term a raise is confusing and not consistent with what repricing has done.
And Mr. Reid, rephrase your question.
Is it a positive impact when somebody does not get step motions that they Is somebody being passed over for for step movement a positive impact?
And based on the criteria that was developed by the department, we wanted to ensure that nobody would have any negative consequences or basically negative pay in or decreases through this process. So nobody was put on a lower salary step than prior to repricing.
So in your opinion, the 6 prior years of experience, actually, I'm going to skip that. You testified there were no violations of the collective bargaining agreement.
That is correct.
Article 20, Section J. Article 20 states there are to be no step motions during the period of time between July 1st, 2021 and June 30th, 2023. Did you move employees did you have step motions for employees in bargaining unit 5 during that time period?
There were no negotiated step movements for employees during that time period.
It doesn't, but did employees move from one step to another during the effective time of the CBA, the 21-23 CBA?
So there were employer initiated movements during that time through the repricing actions, but there were no union negotiated or employer, there were no negotiated step movements during that time from July 1, 2021 through June 30, 2023.
Article 25 talks about rights, privileges, and benefits of employment. What does right, privilege, and benefit of employment mean to you?
So the rights, privileges, benefits, basically that everything that is in the collective bargaining agreement is maintained.
What authoritative source do you go to get your definition of rights, privileges, and benefits of employment?
I think we refer back to the collective bargaining agreement here to ensure that none of the things that have been negotiated are the things that are being negotiated are being addressed through the collective bargaining.
So does the CBA have a definition section?
I don't believe so.
Is there anywhere in the CBA where it explicitly states the definition of what a right, privilege, and benefit of employment is?
I'm not sure.
Okay, so when you talked about that no rights, privileges, or benefits were taken away, what was the source of your definition for what a right, privilege, and benefit of employment is? Or rather, sorry, did you make that testimony? That's probably not going to work either. Have you ever researched what a right, privilege, or benefit of employment is?
So rights, my understanding of rights, privileges, and benefits are all of those things that have been collectively bargained within the collective bargaining agreement.
Would it surprise you that the EEOC says differently?
Objection. The jurisdiction of EEOC is not applicable to this hearing.
I'm going to sustain that objection, Mr. Reid.
Does Hawaii revised statutes provide a definition of these terms?
I'm not sure.
Does the Hawaii administrative rules provide a definition of these terms?
I'm not sure.
I'm not sure. Does the Hawaii administrative rules provide a definition of these terms? I'm not sure. Does the Hawaii administrative rules provide a definition of these terms? I'm not sure. Does the Hawaii administrative rules provide a definition of these terms?
I'm not sure.
on this. Title 38 of Federal Code, the USEERA Act, if I get the acronym correct.
Objection, the federal, whatever he cited, is, has no jurisdiction over, the matter here.
I'm simply stating the only place I have ever found an actual definition
Objection relevance.
of what a
He's just responding to your
Oh,
objection.
yeah. This is the only source of legal authority, only authoritative document I've been able to find that actually defines rights, privileges, benefits of employment. And if it's in the CBA, and if it's protected by the CBA, and there's no definition for it, it's illusionary. And in order for this to have any effect at all, we have to be able to define these terms concretely. And the only source I've found is explicitly in the definitions of a federal law, and this is employment law for them. So it involves the armed forces and being employed and re-employed.
I understand, Mr. Reid, but it doesn't have any applicability in this proceeding. So to that extent, I'm going to sustain the objection.
Okay. Are you familiar in contract law where ambiguity benefits the one who didn't write the contract?
I'm not familiar with the ambiguity law.
Not really law, but it's the well, I guess I can leave it at that because I'm not done just saying that topic. It's about all I can do on that one. You mentioned discussions to ensure that violations didn't occur. You described discussions as a safeguard to ensure violations didn't occur. Was that a preventative action taken by the DOE with the HSTA?
Yes, during our consultation with the HSTA, both parties agreed that negotiations was not needed.
Do discussions to ensure that the outcome guarantee that outcome is achieved?
I guess I'm unclear of what your question is here.
You mentioned how you had safeguards. You had discussions to safeguard against CBA violations or negative impacts. And does simply having a discussion guarantee that was the successful outcome of? I guess that's probably not gonna stand. But is it guarantee that the safeguards weren't? Does it guarantee that the safeguards were effective?
I think that safeguards were put in place, and if there was something that was not being addressed appropriately, I think it would have been brought to the department's attention by the HSTA.
Are wages a right, benefit, or privilege of employment?
I would say yes, it is. I think that being an employee with the department, receiving a salary is a right as being an employee.
I skipped a question. So let me to go back just real briefly. Does the department value experienced teachers?
The department values all of its teachers.
Okay. Is there a difference in work product from a teacher who has no experience and a teacher that has 30 years of experience? generally?
I think each individual teacher has their own unique qualities, and I think each and every one of them performs at different levels based on their ability and what they've been assigned to. And I think that's one of the reasons why we use the EES employee evaluation system to evaluate employees on their performance.
Did the DOE not have 30 some odd studies that pointed to the fact that experienced teachers have better student outcomes, do better work than unexperienced teachers? As a part of the October, several of the memos actually, the DOE memos.
Yes, I think there is some research that's out there that show that, experienced teachers, do provide better results sometimes.
Do you believe that teachers deserve to be paid based upon their ability to do their work? Sorry. Is it the department's goal to pay more experienced teachers more than less experienced teachers?
I think the goal of the compression is to ensure that some of our experienced teachers, we could provide them with the compensation adjustments for when they were working within the Department of Education.
Is experienced labor okay? Okay. Almost.
Back on the record, Mr. Reid, you can continue your examination.
I have, I think, one more question. In the absence, I'll ask anyway. In the absence of any concrete definition of rights, privileges, benefits of employment, how does the DOE plan to comply with Article 25?
Can I reference Article 25 or?
Do you want to reference Article 25, Mr. Bacon?
Yes, am I able to do that?
Yeah, that's right.
Can you repeat your question, Mr. Reid?
In the absence of the definition of the terms in Article of right, privilege, and benefit of employment, how does the department plan to comply with Article 25 with regards to repricing? How did they?
Again, repricing was not a negotiated item, so we did not do anything within the collective bargaining agreement. We ensured that none of our employees had any pay decreases through all of this. And we also we used Chapter 89.9 F2 as our authority to be able to reprice our employees based on their bargaining unit 5 experience. So, I mean, the steps that were given to you at the initial hire, those steps were still there with you. They were maintained. Those were not taken away through the repricing. So I feel that we were able to maintain all of your rights and benefits covered under the collective bargaining agreement.
No more questions.
Thank you, Mr. Reid. Mr. Takea, any redirect?
No questions.
Mr. Alapa, any questions?
Yeah, if I could just ask one thing.
Sure.
One second, let me pull my boots. Sir Bacon, you were asked about the merit principle. You remember that testimony you provided?
Yes,
And you said it came from the HRS. Do you recall that?
yes,
And those HRS 76-1 entitled Purposes Merit Principle, refresh your recollection as to what statute you're referring to?
yeah, I knew it was, I was thinking it was HRS, I just couldn't remember the number.
Sound about right, 76-1 entitled Purposes Merit Principle.
Yes,
And you provided testimony relating to equal pay and equal work under the merit principle. Do you recall that?
yes,
And you're referencing a statute. That was your testimony, yes?
yes.
I'm gonna read 76-1, section 5. And let me know if this refreshes your recollection as to what provision you're referring to. It reads, equal pay for equal work shall apply between classes in the same bargaining unit among jurisdictions for those classes determined to be equal through systematic classifications of positions based on objective criteria and adequate job evaluation, unless it has been agreed in accordance with Chapter 89 to negotiate the repression of classes. Was that the section you're referring to?
Yes.
Yeah, that's all I have. Thank you.
Thank you, Mr. Alapa. Mr. Reid, any questions based upon Mr. Alapa's question?
Just one. I'm a member of bargaining unit 5, correct?
I'm unsure if you pay dues to bargaining unit 5 or not, but you're in a position that could be covered under bargaining unit 5.
Okay. I'm on, well, as upon repricing, I stayed on step 8, correct?
I'd have to look at your exact step, but I believe so, yes.
Step 8 is for people with how many years of experience?
Based on the compression adjustments that we did do, it would be 6 years or more, but less than 8 years of bargaining unit 5 experience.
As of repricing, I had 6 years of prior experience credit and 5 years.
Objection. I believe this is redirect of what?
No, it's about the merit principle.
Oh, it
and
is.
It's, yeah.
Okay, I'm sorry. I withdraw my objection.
Thank you, Mr. Dick.
I'm just making comparison. As of repricing, I had 6 years of prior, 5 years of service, 11 years, correct?
6 years of prior, and then 8 years.
No, 5.
Oh, 5. Yes, 11.
And I stayed on step 8. Is that correct?
I believe so, yes.
So I'm on the same step as a teacher with only 6 years as of repricing. I was on the same step as a teacher with 6 years of DOE service with more than 6 years counted by the DOE in one form or another. Is that correct?
Well, again, we looked at your 6 years of outside teaching experience and then your 5 years of bargaining unit 5 experience to determine where to place you on the repricing schedule.
No more questions.
Thank you, Mr. Reid. Let's see if the board members have any questions. Board member Moipono? You're on mute.
I haven't quite perfected riding a bike yet. Thank you. Okay, I guess, we've been talking about, I guess, outside credit, outside of DOE credit that wasn't, I guess, considered in this formula. Is that correct, Mr. Bacon?
Yes, I think we're looking at the up to 6 years of non-DOE teaching experience that was not credited as part of the repricing plan.
Okay, so other credits that I guess teachers have gotten that were acquired outside of DOE. I think one in particular comes to mind, and that's military service. I think we found out in looking at one of the Senate Bill 2819 that military credit, right, comes under 302A-627. Are you following, Mr. Bacon?
Yes, I'm aware that the military service credit, it comes under 302A-627.
Right, and under that law, it allows for up to 4 years of military service credit. Is that correct?
That is correct.
So was this military service credit not used in the compression fix formulary?
So the military service credit was used as part of the repricing criteria. One of the reasons why it was considered is because it's in statute in 302A-627, and it also is creditable towards ERS service credit. Where the 6 years of non-DOE teaching experience is not ERS creditable service.
Okay, does it say that under 302A-627 about the ERS?
I'm not sure if it says it under 627, but I know that ERS does recognize the military service towards service years towards retirement.
Yeah, but that's under a total different chapter. Okay, the ERS doesn't really come under 302A, does it?
I don't believe it comes under 302A.
Okay. So, but you're saying that the people who got credit for military service, even though it was outside of the DOE service, still got credited for that in your formula for compression fix. Is that what you just said?
That is correct.
And then under, I think we also found that under 302A, there's 624, subsection, I guess it's section B4, that there are other credits earned in, I guess, adjusting teacher's salary. I guess it's listed here, credits earned maybe in the form of in-service. Could you explain what that means, in-service, and how the credits affect a teacher's salary?
So once you're initially placed on the teacher salary schedule, teachers are able to go back and earn additional university courses or department approved professional development courses. And every 15 approved courses can lead towards reclassification to a next higher class. So like teachers that start out in class 2 as a bachelor's, after they receive these department approved credits or university coursework, they can be eligible to be moved to the next higher class.
Okay, and I guess you just answered the next one, university. So I guess if somebody gets a master's or a PhD, then it's for that can give them a step up. Is that correct?
Correct. So those courses that lead towards a degree, like you said, master's or PhD degree, those can be used towards reclassification towards the next higher class. And basically it's every 15 credit hours earned will allow you to move to the next higher class.
And then I think you covered this with board member Monize's question, but let me just make sure I understand this. So the next category is other credits approved by the
I think she muted.
No, we can't hear you.
Board member Moipo, no, we can't hear you.
You're still muted.
I know I accidentally hit one. Sorry.
There you are.
that it's gonna be a long time before I master riding a bike again. Okay, so the last category was other credits approved by the department. Would that include those 6 credits that up to 6 credits that a teacher gets from the department initial hiring?
Let me just review this really quickly, just to refresh myself. So again, I think that these credits earned, again, are the ones that would be used towards reclassification to the next higher class.
Okay, does it say that there? I didn't see that. If it does, can you point that out?
So what it says is, it says credits earned may be in the form of in-service university or other credits approved by the department. So these would be like the department professional development courses that we approve before the teachers would take these in-service professional development courses. So the credit, the word credit is for moving up on the salary schedule or moving from class to class on the salary schedule. This is not referencing, in my opinion, initial years of service.
Okay, and I guess I don't see anything that says exception, so that it wouldn't be elected.
Because I think where it's then referencing is it then goes into the next section field that talks about spending at least 1 year in each class before moving to the next class.
Oh, I think that got deleted.
That did get deleted, yes.
Yeah, so the next one is having to do with the teacher going to an educational officer. So I guess when it says other credits approved by the department, we assume it means credits approved. Unless there is some, you know, if there is any rules that say otherwise.
I think
I didn't hear half of what you said. I think mic wasn't working for part of it.
Yeah, Board Member Moipono, if you can repeat your question, it came across a little muffled.
I'm just trying to define what other credits by the department is. And I just asked Mr. Bacon if there's any rules that would define that.
so. I think that the department puts out an annual reclassification memo to all teachers on an annual basis that talks about how the reclassification process works and what they would need to do in order to submit their university coursework or submit their credits to the Office of Talent Management for it to be reviewed so that they can move them from one class to the next class. This doesn't talk, we're not moving, this is not step movements, this would be movement from one class to the next.
Okay, but I just asked you if there's any rules and standards and procedures or in the administrative rules that the DOE has approved that would speak to this particular section in the law. Do you know, Denny?
I think our annual reclassification memo that we do put out does talk about the rules and how the department implements it for movement based on university courses and classes. I'm not sure if there's a board policy or a Hawaii administrative rule, but I think that we put out our annual reclassification memo that does talk about some of the criteria that are needed in order to earn these credits.
Okay, so you just said you're not aware of any rules or I guess rules that would be included in your standards and procedures. Is that correct?
Yes, like I had mentioned, I think we put out an annual reclassification memo that talks about it so that teachers understand of what the process is on an annual basis.
Okay, so my last question is, these credits that are under number 4, in-service and university, were they considered part of the compression fix?
No, they were not.
Okay, so they were not added to the base salary?
So the compression fixed moved people from step to step. These credits move people vertically across from class to class. So from class 2 to 3 to 4, all the way up to class 7 on the salary schedule.
Okay, I see. Okay, so they were not. Okay.
Correct.
And one last question, because I guess I'm a little confused about how your formula worked. When you said that you gave, I think it was one step for every 2 years of service with DOE, was that on top of the base salary? And I'm, I define base salary as the salary that the teachers compare to the compression fix.
So we looked at the exact dollar amount where they were on the salary schedule, what step that they were on. And then based on the formula that the department had, every 2 years of service credit that they had within bargaining unit 5, we then moved them on the salary schedule to that appropriate step, depending on how many years of bargaining unit 5 experience that they had.
Okay, so you started with their base salary prior to the compression fix.
So yes, this is all about their base salary.
Right. And after this compression fix, I think I read it in one of the bills maybe. So everybody who got an incremental step up, that now becomes their new base salary. Is that correct? And that's part of the DOE budget. Is that correct?
Yes, that is correct.
Okay, so as they go forward, these people who are given these step ups, those are permanent. Is that correct?
Yes,
Okay, thank you.
thank you.
Board Chair O'Cheryl.
Okay, thank you. Thank you, Board Member Moniz. I'm going back to some of the questions that Mr. Takei asked you, in particular I think it was the rules or the process found within the CBA. Let me see. I think I forgot what section that was.
Article 3.
Oh, okay, Article 3. Let me go find that. Article. Okay, okay, here. So we're on Board Exhibit 007. Bottom, page 2, Article 3, negotiating rules. It goes from page stamp 007 to 008. Board Exhibit 1, Article 3, negotiating rules to 008, midway. So there's Article 3, negotiating rules A, B on page 2, C, D, E, F, G, H, I on page 3, which is big stamp 8. Recall that, Mr. Bacon?
Yes.
Now, I understand that the repricing was not negotiated, but it was a decision that was done by the DOE itself. Is that correct?
That is correct.
But yet
It was not negotiated.
Yeah, but yet, in discussing the CBA and the negotiating rules, it seems to me that the negotiating rules contained within the CBA Article 3 was used in the discussion with the union regarding the repricing. Am I correct in that understanding?
I think what we were trying to say is that, they're part of 89.9 F2 talks about a regular process of one of our things that we do would be through the negotiating process to look to determine what types of proposals are going to be put across the table. You know, what are some of the issues that we are facing? How can we address some of these issues? And so those are typically brought up during the initial discussions of the negotiating process when the parties exchange both proposals, and figuring out what we can do to reach to a mutual agreement on that, on a new collective bargaining agreement.
Okay, no, I understand that you would follow that negotiation process and the relevant CBA provision, Article 3 negotiating rules. But isn't it the case in this instance that the DOE chose not to negotiate the repricing, but instead used that provision 89-9F2 to reprice these teachers?
That is correct. We use 89.9F2 to reprice.
Okay, so you gotta explain why the DOE would refer to and use the CBA Article 3 rules in a matter that's not being negotiated, but being undertaken by the DOE pursuant to 89-9F2. If you can explain to me.
I think after repricing occurred, then we were up for a new collective bargaining agreement shortly after. So when we started the process of the collective bargaining agreement, both parties met. We talked about proposals and what, you know, and how we were going to address the next issues that were, you know, facing us, and, you know, what were some of our priorities. And I think that is where definitely, you know, some things were thought about or considered before we move forward with the collective bargaining process. So I think it was a way for us to really figure out, you know, do we need to look at repricing again? Where are some of our issues, and figuring out how we can move forward from there.
Okay, so it sounds like reference to Article 3 negotiating rules arose after the repricing decision had been reached by the DOE.
That's correct.
And it was part and parcel of negotiating with the exclusive representative, the HSTA, going forward on the same topic of repricing.
Yeah, so going forward on the topic of repricing, I mean, there were still, you know, there's always been issues that we need to try to address. And, you know, we want to make sure that we can talk through those issues and figure out how we can best address them moving forward.
Okay, so that goes back to my initial question, and I think also of Chair Moniz. If you look at 89-9F2, and there seems to be a process that's set forward there. You know, 89-9F1 is where you're negotiating the repricing. So that didn't occur here, right?
That is correct.
That's well settled. But when we get to 89-9F2, it says if repricing has not been negotiated under paragraph 1, and I don't think anyone disputes that, the employer shall ensure establishment of procedures to periodically review, comma, at least once in 5 years, comma, unless otherwise agreed to by the parties, repricing of classes within the bargaining unit. And what I have not heard today at this hearing is that there was a process, there were procedures established within the context of 89-9F2, not in contract negotiations, but in this provision. Am I correct?
There's no written procedures, there's no written process. But what the past practice has been is when we, you know, usually the collective bargaining agreement runs 4 years on most occasions. What happens then every 4 years, we come back to the table, we talk about different proposals, talk about different issues, and repricing could be one of those issues. And it may be something that needs to either be done through the negotiation process or not, but at least it's discussed and talked about at the table.
Okay, and you used the terminology at the table, so what I'm trying to ascertain is whether that was done within the context of collective bargaining, negotiating, consulting, in the context of your contract, or under 89-9F2, which I see as two separate processes and procedures. And you can correct me if I'm
Well,
thinking- yeah.
I think it could go both ways, actually. I think, if we went to the bargaining table and both sides agreed that repricing or other issues needed to be addressed, it could be handled through the negotiation process, and it could be negotiated through the collective bargaining agreement. Or it may be something that we've had those discussions, and then it could actually occur outside of the bargaining table, at a later date for us to then look at how we can do repricing. So I think it could happen either way.
So in this instance, pursuant to Act 248, was the contract being discussed, or was it this 89-9F2?
So 89-9F2 was what was being discussed for this current set of repricing, yes.
Okay. That helps me, because then I can understand the context in which this term used, consulting, using consulted with the union.
Okay.
But when I hear consulting, I'm thinking, 89-9, right? Scope of negotiations or consulting. And I'm trying to square that with the statutory requirement of negotiation consulting.
Okay.
So the term using consulting, is that within the chapter 89-9 description of consulting vis-a-vis negotiating?
So it wouldn't necessarily be negotiating unless both parties mutually agreed to negotiate. Then we could go through 89-9-1 if we needed to, and then actually mutually agree to negotiate. However, that didn't occur in this case. 89-9F2 occurred in this case. So we were able to do it employer discretion. However, part of it does talk about having a process to look at in case we need to look at repricing again. Was it successful? Was it not? Do we need to make additional adjustments? And I think that occurs every 4 years. I think when we go back to the bargaining table, when we start putting proposals together, the concept or the idea or the thought of, do we need to reprice? Do we need to do other types of issues to try to address any teacher shortages of recruitment and retention? So again, it may happen next time, possibly through a negotiation process. It may happen again next time through an employer initiated process too. But I think that the key concept here is we've got to look at where is the issue and how do we address the issue moving forward.
I appreciate that, but I'm for the purposes of this hearing, I have to go back in time.
Okay.
And understand what occurred at the relevant time when the decision was made to go ahead and implement this repricing for all the right reasons. The intentions are, I'm not questioning that. I think everyone had the right intentions. I'm just looking at the statute and what it requires under 89-9F2. If there was procedures established, and it seems to suggest that it'll be done at least every 5 years, and unless otherwise agreed to by the parties. So I'm reading that the parties would be the employer and the exclusive representative. In this situation, it would be the DOE and the HSTA.
Okay. Yes.
So there's some agreement on the process, the procedure, how they go about, reviewing the repricing, right? Was there anything like that when you folks went ahead and did the repricing under this provision and informed the teachers, and the memo was issued by the superintendent, And the PowerPoint was given to the Board of Education. And the legislature was informed about how the monies were going to be spent. Was there some procedures established?
I think one thing that was indicated in the memo to the Board of Education from the superintendent is we were going to continue to monitor this through the board, through some of our metrics and other ways to see did some of these compression adjustments make a difference to our recruitment and to our retention. But also, like I had stated earlier, I think again, there were some issues that were not handled through this compression adjustment that I think both parties agreed that we continue to work through those at a later date, possibly through negotiations, possibly through other means. But, there's no written document, there's no written agreement to show what that looks like, except for, in the contract, it talks about the negotiating rules.
So is it safe to say there was no meeting of the minds of the parties to establish or settle some procedures for the periodic review of repricing within the bargaining unit?
I think it's fair to say that both us and the union knew that this repricing fixed some issues. It didn't fix all issues, and that we were going to need to continue to work together, either through the collective bargaining process or through other processes to see if we can still make improvements moving forward.
And if I think the testimony that I heard earlier rings true, that I think the DOE and the union did actually try and going forward, I think in 23, weren't you folks trying to resolve the 3,000 or so members that were not, maybe were left out on the first phase of the repricing?
Yes, and I did go back and look a little bit at my notes too, and that there was a proposal brought up to the HSTA from the HSTA through the collective bargaining process to talk about, could we give more than 6 years of service credit towards individuals? And I think part of the proposal allowed for, or was requesting up to, I think, 22 years of service credit. So again, it was trying to be addressed again, even after the compression adjustment was made, to see what we could do to move forward to still continue to assist our teachers as we move through this process.
And was it resolved through the negotiating process?
That portion was not resolved, no.
So as we sit here today, is that still pending issue in negotiation, or is that?
But I think at this point right now, the state and the department and the union have agreed on a new 4-year contract at this point right now. But it doesn't prohibit us at all from still looking to see, are there other ways that we can continue to look to assist our teachers as we move forward here.
Okay. Thank you, Mr. Bacon.
Thank you,
Chair.
Thank you. Mr. Bacon, just to touch upon what Board Chair O'Shea was getting at with Article 3, and frankly, I'm also a little confused as to why you were questioned about this article. So I want to clarify a little bit. Article 3 deals with collective bargaining, right?
Correct.
And that deals with the negotiations to determine the language and conditions of a collective bargaining agreement, correct?
Correct.
This whole process that we're talking about here, this repricing being done under F2, that has nothing to do with collective bargaining or determining the language of a collective bargaining agreement, does it?
Correct.
Because even Article 3 provides, like in Section D, for an agenda that needs to be accepted by both of the parties. And I would presume that would be in writing. And in Section I, that all the items agreed to tentatively pending final disposition of all items being negotiated, none of that was done in this case, right?
None of that was done in this case. So I think really what we had done is we had done repricing through 89.9 F2. At the end of it, we knew that there were still some additional things that could be addressed and looked into. And I think one of the things is moving forward, we wanted to see, could we address some of these through negotiations, or could we not address some of the negotiations?
Okay. And you, well, let me ask you, one of the questions too was that the up to 6 years of credit, I guess Mr. Takei had made an issue of that. It was located in the provisions for the 2021 to 2023 contract period. You recall that? He was asking you some questions, I believe. I forgot what exhibit it was on C88.
I know we talked about that. We could give up to 6 years of credit in the collective bargaining agreement. Yes, under the,
Okay.
yes.
And my question is, how long has that existed as a policy of the DOE?
The 6 years of credit has been in the school code for decades, probably. I don't know the exact amount of time, but it's been there for quite some time.
Okay. So it's not something that just simply appeared in the 2021 CBA to 2023, right? It's a long-standing practice.
Correct.
And regarding that 6 years, it's, and to be correct, it's up to 6 years, correct?
Correct. It's up to.
And it's the DOE is the sole authority to verify that prior teaching credit, correct?
Yes, we had the employee fill out a verification of employment from their previous employer, and then we review that to determine whether or not it would be accepted or not.
Okay. And then it's up to the DOE again solely to determine if you're going to give 4 years, 3 years, or 6 years. That is again solely a decision made by the DOE.
Well, we're following the school code and the contract, but basically, yes, we would do the review and then we would make the decision. Yes.
So you could decide based on your review to give someone 4 years of prior credit based on the review and what the facts and circumstances are.
We could give them up to 6 years. Yes.
So it's not a foregone conclusion that everybody gets up to 6 years.
And yeah, the employee would have to submit a verification of employment from their previous employer to show that they had that equivalent teaching experience.
And so that's given at the initial hire.
Correct.
And so once you pass your initial hire date and you've been given, say, the 6 years of experience, right? That doesn't go away, right? I mean, that credit is there for the time period that you're employed with the DOE, right?
That is correct.
Now, you touched upon safeguards, and one of the safeguards was the ability or opportunity to contact the union. Was that one of them? That's what I have in my notes. Is that correct?
That was one of them. Yes. That,
if this is being done pursuant to 89.9 F2, repricing, unilateral action by the DOE, what kind of safeguard is it to have an opportunity to contact the union?
I think what had occurred is if they did contact the union and something was brought to the union's attention, then the union would bring that to us, and then we could definitely review to determine whether or not we had appropriate years of service or not. So we just wanted to give employees an opportunity, to go in either direction.
But again, it's something you, because the DOE, let me see, I didn't mean to say you personally, but the DOE can accept or reject under F2.
Correct.
And what is the purpose behind granting up to the 6 years of credit or experience? What is the purpose behind it?
I mean, I wasn't there when it was originally decided upon.
Your understanding.
That, but I think the purpose of it is to be able to give additional compensation to employees for their service or when they were working at a previous school district.
Would you agree that it's to help recruit and retain qualified teachers for the DOE? Then you mentioned that you have done repricing previously to the situation that we're here discussing. Is that accurate?
So I think
That's what I have in my notes.
with other classes of work outside of teachers, we had done repricing.
Okay. And so people other than teachers, when that repricing was that done pursuant to 89.9 F1 or F2?
I think it was done 89.9 F1. I think some of it was done.
And if not all of it, then was the rest of it done pursuant to F2? If you can recall.
Yeah, I can't recall. I don't know off the top of my head.
Okay, thank you, Mr. Bacon. I have nothing further. Mr. Reid, any questions based upon the board's questions?
Just a couple. Did you testify that military service was accepted because it's contained within 3028-627?
Yes, it talks about military service. It's 27.
Was prior teaching experience also present in 302A-627 before it was repealed at the request of the Department of Education?
Yes.
So so was it your prior testimony that repeal? Give me a second. If the department, yeah.
Take your time, Mr. Reid.
Is the reason that the repeal of sections of 302A-627 was it to enable not counting the 6 years of prior experience in repricing?
No.
What other function did it serve? That's yes.
So this, that section was again, it's about initial classification or initial entry into the department.
Does it not refer to entering and re-entering the department?
Yes, it does refer to entering and re-entering. So those are that are new hires entering the department, or those that were previously employed left and then are coming back to the department.
And In the absence of the repeal, would you have made the same decision to not count the experience?
Yes,
Would there not have been? To the best of your knowledge, are there federal laws that protect benefits from military service?
I'm not sure. I'm not on that one.
Did the department foresee legal issues if they tried to erase the credit for military service in repricing?
I do not believe that was considered.
No more questions.
Thank you, Mr. Reid. Mr. Takei,
No questions.
Mr. Alapa.
No questions.
I do have one clarifying question that I forgot to ask.
Yep.
Mr. Bacon, was this the first experience you can recall of doing a repricing under 89.9 F for you personally?
For me personally, yes.
Thank you. I have
Thank you.
nothing further. Anybody have, Mr. Reid, any questions based upon my question?
No questions.
Mr. Takei,
No, sir.
Mr. Alapa?
No.
Board Member Moipono, you have anything further?
Just one question following up on Mr. Bacon, that the 6 years credit was in the school code, did you say, Mr. Bacon? I didn't get where you said it was located.
I had a
I'll
hard,
just sit
I had a
forward.
hard time.
Hey, can you repeat the question? You're a muffled board member.
Closer.
As long as you're close to the mic, we can hear you.
Okay. Okay, I think, Mr. Bacon, you had mentioned that the up to 6 years of credit was in some kind of a school code. Is that correct?
Yes, it's in two locations. It's in the department's school code provisions that apply towards certificated employees only. It does not apply to classified employees. And then it also is in the collective bargaining agreement, and it's Article XX salaries.
Okay, and would you by chance know the site for that school code? The section that it's contained in?
It's 5,200 something, but I don't know the exact citing off the top of my head.
Oh, okay. Okay, that's it then. But it's in a 5,200, you said?
Yeah, it's in the school code 5,200 series, but I don't have the exact number where it's
Okay.
at.
Okay, I'm sure it's probably on your website, the DOE website, is that correct?
The entire school code is on the DOE website. And we can get that information to you if you need, board member.
Okay, that'd be great. I don't need it in hard copy. Digital would be fine. Thank you.
Thank you.
Board Chair O'Shea, anything further?
No, nothing further. Thank you.
And nothing further from me. With that, unless anyone has any other questions, Mr. Bacon, you're excused as a witness. Thank you very much.
Thank you.
Mr. Takei, you have any further witnesses? I mean, not just for today, because we're about to recess.
Oh.
But just, do you have any further witnesses?
Yes, the complainants.
Can you tell us what order you will call them tomorrow morning?
Mr. Reid, then Ms. Campbell, then Ms. Beth.
And other than the three complainants, you have anyone else?
No.
All right, so you understand that, Mr. Reid?
Yes.
Campbell, Ms. Best. So with that, we will stand adjourned for today and we'll reconvene at 9 AM tomorrow morning. Thank you.
Yeah.
Thank you.